not with my colleagues. I certainly believe my colleagues is to try to get along with them as best I can. And even though, obviously, we don't agree, and they seem to be quite upset with me, it's okay. We should get the work done. And that's what I proceed to do. While 3 of my colleagues now have refused for 4 times in a row to come to our meetings at the Chief Justice's request, and even at my reminders twice for them to please come to the conferences and do the work of the court. I would remind them that there's another canon. It is Canon 3, and I reminded them, in fact, I have what I sent them this morning again for the 4th time that we've had it, the 2nd time I've written them about it. I quoted to them that canon, which says, and if you'll give me a moment, I will pull it out here. Just a second, it's that order. A few papers involved in this issue, as you might imagine. So it's Canon 3B1. The canon that the gag order is in violation of is Canon 3A6. But 3B1 urges all, and I would like to quote it for you if I can find it here amongst my papers. You'll be patient with me. In any case, it says that we all have a duty to facilitate the work of the court with other judges and for staff. The repeated absence of justices for reasons that they think they can't do the work of the public in an open fashion or be accountable for what they do after they've done it and when a case is closed. The fact
Justice
of the matter
Weaver,
is,
with
just
due
a minute,
respect,
Justice Carter,
Justice
I'm
Weaver,
still speaking.
What did we reply to your requests to come to conference?
Justice Cargan,
What
I'll let
did
you
we-
tell them.
What did
I
we
didn't memorize
say?
what you have to say.
I see.
Why don't you just bring it up?
Call the question.
Call the question.
Okay.
No, I want
to
just a
say one
moment.
more thing. I taught first grade for 3.5 years. The public is not interested in tattletaling. And I do believe the public will take care of tattletale judges. But I do know the public is interested in knowing more about not only what we do, but how we do it and when we do it. And if you'll read Canon 3A6, once a case is closed, it's no longer pending or impending. That canon, and only the suggestion, the voluntary abstaining, ends. Now, that's what this is about. And I'm sorry that my colleagues don't like my proceeding to have more openness, more understanding, more accountability of what this court decides. When we put out a convoluted decision that has 6 opinions and has to be subject to a motion for reconsideration and a motion for clarification, and after the case is absolutely closed, and one of the attorneys asks me something about it, and I say, oh, well, it was probably this, but people, for their own reasons, as best I can figure, change their mind. I have every right to say that, and people have a right to that answer. My colleagues don't like it. That's the way it is.
No one in the public should be confused, and I think no one, whether they're a lawyer or not, would be other than shocked to know that a justice of this court shared the confidential communications about a case to a lawyer who was a party in a related case that gave him strategic information about the receptivity that members of this court might have to a motion he has subsequently filed. That is what we're talking about. We are talking about a communication that aided a party and related litigation. This is a shameful thing for this court. It is even more shameful that Justice Weaver, who has now been referred to the JTC, is attempting to remove one of the bases for her referral. I am utterly ashamed of her conduct. I'm utterly aghast that the members of this court have not attempted to address a serial disclosure of the confidential communications of this court, and in this last case, to the aid of other parties outside the court. This is a shameful thing for any senior court, and the public need not be confused by the elaborate weave that Justice Weaver has put out. This is a serious problem that the Chief Justice of this court and the other members of this court must address. I am going to continue to communicate my votes via writing because of this problem.
Okay, can we call for the question on this?
Yeah,
Can I say something,
called
please?
for it.
It's been called for. Do you feel it essential to say
Yeah,
more?
of course I do. Justice Weaver self-characterizes herself for about the 1,000th time today as the victim of a gag order by this court. I believe I can say with confidence, and as the official Michigan reports will confirm, there's never been a more ungagged member of this court, especially when it comes to breaching the kind of confidences to which any judicial body is entitled in its deliberations. Our former Chief Justice Cliff Taylor remarked several years ago that despite the fact that a justice of this court, and this was several years ago, has now engaged and continues to engage in the unprecedented act of revealing deliberative confidences, every word of every statement of hers has been made public exactly as she has written it, and that observation remains true today. She has not been gagged by this court. Once again, she is the most thoroughly ungagged member in the history of this court, and I think the public interest is not in openness exclusively, but it's an ethical, responsible, and hardworking behavior by the Supreme Court of its state, and they deserve that, and until they can get that, it makes it impossible for this court to live up to its full potential.
Okay.
I do need to answer Justice Young because he's been inaccurate in his characterization of a disqualification that I had to disclose.